Hi, my name is Ray Kerlick. I'm a partner with the law firm of Wadler, Perches, Hundl, and Kerlick in Wharton, Texas. Today I'd like to talk a little bit about something that most of our clients in the oil field industry are very familiar with, and that's MSAs, or Master Service Agreements. A Master Service Agreement is typically something that's put out by a large company in order to qualify vendors to be added to their preferred vendor list. Now, normally the provision that you're undertaking is to get more work from this customer, and so as a small contractor or small business, you're certainly going to do what you can to get that work. But oftentimes when we are receiving and reviewing master service agreements on behalf of our clients, we've had clients that say, based on what they want us to sign off on, we're not sure we want that work because there's certainly going to be costs associated with taking this work. Costs such as insurance, indemnity provisions, certain types of regulations that need to be followed that may not be actually applicable to you, perhaps ways that billing and other invoices have to be sent out. So what does a master service agreement do? It's something in writing that says no matter what the purchase orders or invoices between us might say, and certainly regardless of what may be said over the phone by way of an oral order, the provisions in this contract apply first. Now normally they're not very specific, but certainly they normally apply to how soon and how often you can invoice things to the company, what has to be in a purchase order, who has to sign off on a purchase order, and what types of items can be charged for and what items can't be charged for. Oftentimes an MSA will include a price list that gives you a list of how much things will be charged and what your agreed price lists will be. Perhaps most importantly, typically to the company with whom you're doing business, is the indemnity and insurance provisions. What they want to make sure of is that you've agreed to indemnify them from any claims that might arise out of your work out of the project. Further, they want to make sure that you have liability insurance sufficient to cover any lawsuits or claims that might arise out of the work on their work site. Now, Texas has very specific provisions dealing with oil field indemnity. In fact, there's something called the Oil Field Indemnity Act. Now, what it says is indemnity provisions have to meet very specific technical guidelines, both in the language they use and the types of insurance that support them in order for them to be enforceable. So, normally, these provisions are included in an MSA. Normally these are not negotiable items. However, there are oftentimes additional provisions in the indemnity and insurance that are negotiable. Because they are very technical, oftentimes only an attorney would be capable of parsing through the language that you find in these documents to find what's negotiable and what's not. This is certainly a service that we provide to our clients, and we'd be happy to discuss your needs and the items that are being requested of you on a short turnaround basis. We look forward to hearing from you and appreciate your time. Thanks.